very fortunate to have so many of our candidates who are able to join us this year. Every year, every 2 years when we have these meetings, we talk about the importance of the judiciary and the importance that these kind of meetings play in getting the information out about candidates and raising some profile for these races. That's particularly true this year. The ballot will be very crowded, and we owe it as lawyers to do our part to make sure that the public knows about these races and knows the men and women who have offered themselves as candidates here. This is not something that most of us choose to do. It is a service that these ladies and gentlemen have undertaken, and we appreciate their willingness to put themselves forward and to go through processes like this. So we thank all the candidates, and thank you particularly for showing up here today to be with us. We will start with the seat for the North Carolina Supreme Court. This is the Brady seat. The questions were given to the candidates in advance. I will read them to you again, though, now. Pursuant to the North Carolina Rules of Civil Procedure 12, 50, and 56, the court is required to remove cases from the jury when justified by law and the evidence, regardless of the consequences to the parties. But many trial judges appear reluctant to do so. Following the guidance of the U.S. Supreme Court, federal judges in North Carolina and elsewhere have been increasingly apt to dismiss at the pleading stage those cases offering no plausible argument for merit, and many federal cases are dismissed or pared down by summary judgment upon the conclusion of the discovery. Is it time to follow the federal example and give our trial courts guidance and encouragement to enable them to properly weed out or to narrow appropriate cases? And the question will be answered by Judge Bob Hunter and Judge Barbara Jackson. We're going to go in alphabetical order, so Judge Hunter will address first, and then Judge Jackson. Bonnie Rafinsky is keeping our time down here. She'll give you a 1-minute warning, and then we'll stop you. Judge Hunter.
Thank you, David. I assume that the 5 minutes is not just to cover that question, but to talk about ourselves and why we think we're qualified to ask for your support in this election. And first of all, let me say I thank you for your endorsement very much. I've been blessed in this race, and I've had the endorsement of every major group that I know of that's endorsed, so I certainly appreciate that. I enjoyed being with y'all at Hilton Head, and it's a special pleasure for me to be here today for a couple reasons, one of which, and I didn't know about it, is my good buddy from Marion, Charles Bergen, just receiving that award. Charles, it's really great to see you get that, because you certainly deserve it. I've practiced with him for 29 years in the same town, and I know what kind of quality person he is, and Bunny equally. And also, he's helping me in my campaign, so I appreciate that too, Charlie. The other reason it's a pleasure is I get to see my daughter today, I hope, maybe even sit beside her at lunch, although usually I try to sit beside people I don't know when you're running in an election. But my daughter is here today. I was blessed and proud to swear her in, I think 3 weeks ago, and she is now practicing in Raleigh with Yates, McLam, and Wire. So, Claire, good to see you, and we'll get to spend a little time together, I hope. I'm very, very proud of you. Let me talk a minute about my background and try to get into that question a little bit. I've practiced law for, it's not quite correct in the bulletin, from 1969 to 1998 when I went on the Court of Appeals. So it's 29 years, Zog. And during that period of time, I think I gained an appreciation for what it's like to practice law. And I did some plaintiff's work, but I had a significant amount of business practice as well, Steve. And and I was county attorney for 24 years. I was in the legislature where we had to deal with significant business issues. Matter of fact, those of you who are LLCs or anything along that line, that was the legislation that I sponsored in the General Assembly. And I sure was thankful to have some very qualified lawyers and CPAs who knew a lot about that bill when we did it, because at that time it was very new, and it was something that was very much needed in the state. I also was involved in some small businesses as well. So I think I know from a business perspective, from a defense perspective, what you face. I've been on the court for 12 years, heard 3,600 cases, I think, written about 1,200 opinions. I hope you like most of them. I'm sure there's some that you didn't. But I'm sure on the other side, from the plaintiff's bar, the same way. That's why I'm most appreciative to have the endorsement of both groups and the endorsements of people like some public defenders as well as DAs and law enforcement groups and teachers and women attorneys and others. But I hope that means that they trust me. They trust me to be fair, that they think I'm fair and balanced and a good judge or a fair judge, because that's what I work hard at trying to be. And that's what I've tried to do on the Court of Appeals and what I will take to the Supreme Court if you and others are kind to me. And I'd love for you to be as kind to me as you were in 2006 when I visited all 100 counties and I carried 99 of them. But and now she's giving me, Bonnie's telling me I've only got a little bit of time to answer this question. But I think that I can do that because the question, of course, talks about where the pleadings offer no plausible argument for merit. So I think that's easy. Sure, those ought to be weeded out at either Rule 12 or 50 or 56. I think the key thing, and of course, when those motions are denied, you don't have a immediate right of appeal. You have to wait until the case goes all the way through. I would hope that they would be ended if there's no plausible argument for merit, that if the trial court didn't take care of it at some stage, that the jury would. So I would hope that we don't see many of those. But when we do, those are reviewed de novo. And, of course, the key question there, is there a material issue of fact? So that's where the discussion comes in. And if there's no material issue of fact that affects a plausible argument for merit, then of course they should be dismissed, and I would hope if they get up to our appellate level that we would address the question, and if guidance is needed, that one of our panels would provide it or the Supreme Court would provide it. Thank y'all very much. It's great to be back with you, Richard. Good to see y'all. Thank you.
Judge Jackson.
Thank you all so much for inviting us here today. I am Judge Barbara Jackson of the Court of Appeals, and I also appreciate your endorsement very much. I hope it reposes confidence in what I've been doing at the Court of Appeals since 2005, and I hope that you will support me in this bid for the Supreme Court. You have a brief bio of me in your program today, a more extensive one in the Defender, and I hope you'll take time to look at my website, judgebarbarajackson.com, or visit me on Facebook at Judge Barbara Jackson, or if you're really hip, follow me on Twitter at Judge Jackson. I'm not so hip, but I'm really trying. You have asked about plausibility, and I went in and looked at Twombly and Iqbal and checked to see if North Carolina has looked at that. And Judge Stroud in the Holloman versus Aiken, and yes, that is Clay Aiken, is the only case where we've looked at it, and appropriately for our intermediate appellate court, Judge Stroud noted that it would be inappropriate for our intermediate court of appeals to adopt that Twombly plausibility standard. So we declined to adopt it, and she wrote basically that that 12b6 motions, whether the standard still is, whether as a matter of law the allegations of the complaint treated as true are sufficient to state a claim upon which relief may be granted under some legal theory. The complaint must be liberally construed, and the court should not dismiss the complaint unless it appears beyond a doubt that the plaintiff could not prove any set of facts to support his claim which would entitle him to relief. The Court of Appeals conducts de novo review to determine the pleading's legal sufficiency. That case didn't go any further. It was interesting reading, though, because it was, in this case, this theory of plausibility was brought forward by the plaintiff, not the defendant. And I went back and looked at the briefs because I was just really struggling with it, and I have to concede, I was thinking about it during the movie's presentation earlier, and the line from The King and I came to mind. It is a puzzlement. I couldn't really understand the theory that the plaintiff was trying to advance in that case, trying to go with the plausibility standard, because it seems they've tried to run away from it for the most part. One of the commentators that I read posed an interesting question, that if it's not plausible, why should an attorney be following it? And I think that's an interesting question that we will be grappling with, and certainly one that it would be reasonable to pose to our courts going forward. I confine my analysis in looking at these cases to state courts. I think the federal courts have been pretty clear, but I think that they're grappling with different problems perhaps than the state courts are. And Nebraska has looked at this analysis in the Doe versus Board of Regents of University of Nebraska case, and they chose to adopt the analysis. They said that they found that the decision in Twombly provided a balanced approach for determining whether a complaint should survive a motion to dismiss and proceed to discovery, and that accordingly that they held that to prevail against a motion to dismiss for failure to state a claim, the plaintiff must allege sufficient facts accepted as true to state a claim for relief that is plausible on its face. So they were accepting of that theory. However, other courts have not been as accepting. In Roth versus DeFelice Care, West Virginia's Supreme Court rejected those pleading requirements. And in McCurry versus Chevy Chase Bank, the Washington Supreme Court also declined to adopt the Twombly-Iqbal standard and stated the Supreme Court's plausibility standard is predicated on policy determinations specific to the federal trial courts. Twombly concluded that the federal trial courts are incapable of preventing discovery abuses. Weak claims cannot be effectively weeded out early in the discovery process, and this makes discovery expensive and encourages defendants to settle largely groundless claims. Neither party has shown these policy determinations hold sufficiently true in Washington trial courts to warrant such a drastic change in court procedure. And I found that case to be really compelling, and I think if someone were to come forward to the North Carolina Supreme Court or to our courts in general, that those would be good arguments to advance for us if you would like the North Carolina courts to look at a plausibility standard. I, like the Court of Appeals, would be somewhat reluctant to change our standards just on the basis of what the federal courts are doing for a whim. But if some strong arguments like those were advanced that showed that there was a need for North Carolina to change our standards, you know, because of some of these types of concerns that were raised in the Washington Supreme Court case, I think those would be compelling reasons to advance for us to take a look at doing that. So I thank you for taking the time to listen to us today, and I hope you'll take the time to consider my candidacy for the Supreme Court. Thank you very much.